to every story.
No, there are more than two sides.
Is it the new PDP or the old PDP?
No.
If you look at what happened,
you can't.
That your PDP went to court and they challenged on Oyinlola.
A community without a common ground will eventually become a battleground.
This is Pastor Chibo phoning from Obu local government, Enugu State.
Okay, let's go ahead.
Political Voices in my CNN here. I love it, and I love it very much. My name is Lily from Kogi State. Political Voices always keeping me busy, always making me happy as I'm on strike as a student.
Political Voices. One story, many angles.
Listen, I am telling you that
I don't agree. I don't. No. You can't say that.
Politics. Where is good governance?
Everyone is a political animal.
I don't like politics.
But I love Political Voices.
On Political Voices, we talk politics. In a country of diverse interests, who gets what, when, and how is politics. And this is our business on Political Voices. Nigeria, a country of over 160 million people. Political Voices is gauging the temperature, setting the agenda. Political Voices exclusively on Dream FM, 9 o'clock in the morning, Monday to Friday.
Good morning and welcome to Political Voices on 92.5 Dream FM. And of course, Political Voices is a session of comments, interviews and analyses of trending political stories as they affect and shape the world around you. Today is Friday. Someone says, thank goodness it's Friday, the 28th day of August 2020. This morning, we turn our attention to the executive orders and democratic governance in Nigeria. But before we get into the discussion, there are a few matters arising from the political space. Former Speaker of the Parliament of the Economic Community of West African States, ECOWAS Parliament, Senator Ike Ekweremadu, has congratulated the President of the African Development Bank, Dr. Akinwumi Adesina, on his re-election as the President of the bank. Reacting to the development, the former Deputy President of the Nigerian Senate described Adesina's re-election as a landmark victory, not only for Nigeria, but also for Africa as a whole. Ekweremadu wished Dr. Adesina well and prayed God to grant him the grace to continue on the path of excellence. Playwright and social critic Professor Wole Soyinka has faulted attempts by the federal government with the connivance of the National Assembly to return the National Water Resources Bill rejected by the public in 2018. There were reports that the House of Representatives on July 23, 2020, referred the National Water Resources Bill 2020 to a committee of the whole for third reading and passage. Soyinka, in a statement on Thursday titled MLK's Mighty Stream of Righteousness, kicked against the return of the bill and the killing of some members of the indigenous people of Biafra by officials of the Department of State Services in Enugu on Sunday. Those are some of the issues making the rounds in the political space. Remember, we are streaming live on 3 platforms. On YouTube, we are live on Dream TV Enugu. Remember to subscribe and turn on notification to catch our live videos when we do stream them. And in case if you missed any edition of Political Voices, visit our YouTube channel at Dream TV Enugu to watch it. On Facebook, it's 925 Dream FM, and on Twitter, it's Dream 925 FM. Whichever one that is your choice, make sure you watch us live as we have this discussion. You can send us a WhatsApp message on 0902 0020 925. Stay with us. Do away with executive order or risk dictatorship. That's the warning coming from former Deputy Senate President Ike Ekweremadu He says that unless Nigeria does away with executive legislation through executive orders, the country may be heading towards authoritarianism and possible dictatorship. Former Deputy President of the Senate, Senator Ekweremadu, is making this known. Ekweremadu stated this while delivering a paper on executive order and democratic governance at the 60th conference of the Nigeria Bar Association in Abuja on Wednesday. He says that democracy envisages the division of governmental powers into 3 different arms, each with distinct powers and responsibilities clearly provided for in a country's grown norm. The philosophy behind this compartmentalization of powers is the need to preserve the liberty of citizens and prevent abuse and tyranny by one arm of government over the other. He goes ahead to quote Section 4 of the 1999 Constitution, which provides that the legislative powers of the Federal Republic of Nigeria shall be vested in the National Assembly. The National Assembly is to exclusively legislate for the peace, order, and good government of the Federation or any part of it, with respect to any matter on the exclusive legislative list in the second schedule to the Constitution. And he goes ahead to say that the only section in the Constitution that confers the executive with some form of quasi-lawmaking powers is Section 315 of the Constitution, which provides that the President or the Governor, as the case may be, may modify the text of an existing legislation as he considers necessary or expedient to bring such law into conformity with the provisions of the Constitution. And matter of fact, he made a clear point, and he also cited Executive Orders 6 and 10 of President Muhammadu Buhari's administration as examples of overreaching executive orders. He reminded everyone that as much as the president had good intentions to get the governors to implement anything he wants, he says that the houses of assembly and state judiciary need the autonomy, and he says that a few other things. He says this does not in any way represent what they amended in the Constitution. Remember, he headed the Constitutional Amendment Committee in the previous National Assembly, and of course he's making that case. He said, do away with the executive orders. And I'm joined this morning on Political Voices by 2 eminent lawyers. First, I have Barrister Cosmos Okolo, an Enugu-based lawyer, public policy analyst, and the executive director, Amrich Leadership Center. Good morning to you, sir, and thanks for joining us on the program this morning.
It's my pleasure, Alex. Welcome, listeners.
Also joining us this morning is Dr. Chijioke Abo. He is an Enugu-based lawyer and political analyst. Good morning to you, sir. Good to see you again.
Thank you very much for having me. Good morning.
All right. I'll start by asking you, Dr. Chijioke Abo, when we talk about executive orders, I'm sure you have some sort of thoughts about it. But first, I would like to get your reaction on the call from the former Deputy Senate President. What's your take on the submission of the former Deputy President of the Senate on the issue of executive order?
Well, I think Senator Ekweremadu chose a very distinguished platform to canvass his views. I share in his concerns, really, because historically, you will recall that concentration of powers brings about abuse. And that was why the likes of the French philosopher Montesquieu talked about separation of powers, so that powers are not concentrated in the same body of individuals, or indeed in an individual. You'll recall that President Clinton once said that in Africa, we have strong men, not strong institutions. And so when you allow executive orders and they translate to executive legislation, then there is the tendency of it being abused. I think that is one. But historically, it's not been with us. I think we are copying perhaps from America. But we must also underscore, their political development and ours, whether really we are ripe for that. And whether the section that is always relied on, Section 315 sub 2, gives the president legislative powers, and so to compete with the parliament as to who has powers to make laws. But beyond that, I must also say that, some laws make room for subsidiary legislation. When you talk of laws like the enforcement of fundamental rights provided by the Constitution, the Chief Justice of Nigeria, for instance, is given powers to make subsidiary legislation, as to the procedure to be followed. But that does not mean that legislative powers is conferred on him per se, so that he can now begin to issue out orders at will. The problem with Nigeria is that since this present presidency, I think we have had about 10 of such orders, and there is a tendency that it will continue. And so we begin to wonder whether really, given the provisions of sections 4, 5, and 6, which clearly are on the principles of separation of powers, whether they now give the president those powers to continue to legislate, and whether those executive orders really translate to, exercise of executive legislation to the extent of competing as an institution vis-a-vis the National Assembly. But as we go on, we will also highlight some of the concerns, particularly Orders 6 and 10. Order 6, I think, with respect to local government autonomy also, and Order 10 with respect to autonomy for the state legislatures and the state judiciary. But one thing is to give them that autonomy financial. Another thing is to allow them also exercise that autonomy in terms of recruitment and discipline of judges and magistrates and those who come in. Because you can't say you're giving financial autonomy when, of course, through the other door, the executive is overbearing in the recruitment of judicial officers. What do you expect in a system like that? So that is why people are concerned. And as we go on, we will begin to analyze in fuller details.
All right, then. Barrister Cosmos Okolo, you've heard him. Well, talk to us about your major concerns about the executive orders. Are they coming because the legislature cannot legislate on such matters, or is it something that is just convenient for the executive to do so?
Yeah, thank you very much, Alex. I align myself with the revered submission of Dr. Abo on the matter, but I would like to add, by way of answering your question, that the major challenge we have in Nigeria in our democratic development in this dispensation is that we have a militarized and feudalistic constitution that was imposed on us by the military by Decree number 29 of 1999. That constitution is the foundation of what we are going through in Nigeria. And until we go back to address it, we can't make any headway. Section 2, subsection 2 of this constitution we use says, Nigeria shall be a federation consisting of states and a federal capital territory. In other words, being a federation, the federating units shall be the states and the FCT, not the central government, not the federal government. But if you go to the second schedule, which Senator Kwemadu referred to, you will see 98 items of power. But the crucial issues of governance, the core issues of governance, are reserved and domiciled for the central government. Out of 98, 68 is domiciled with the central government, the federal government. And these are the core issues that make a nation move. And whoever emerges as the chief executive at the center, the president, possesses enormous power, tremendous power. In fact, somebody described it as power to kill and make alive. He said there's no president in the world that has the kind of power Nigerian president has. Now, how can you reside such amount of power with the center, which is not a federating unit, and expect the system to move forward? So what we've seen now is that because the constitution is military in nature, because it has a feudal origin, where the overlord sees the other federating units, which has which you have the core powers, items of power in governance, they now come subservient. They now come as though they are an appendage of the central government. Every month they go begging for resources to sustain themselves, whereas the power ought to domicile in the federative units if actually it's a federation. So in view of that, the center, the federal government now sees itself as the overlord in that feudal enclave. And whatever they like, they do. You can't do anything. The states go cap in hand begging. So that's the root of the problem we are going through. And like Senator Kremori referred to, which Dr. Bo highlighted, executive order. Executive order is not wrong. Executive order is not a law. And you cannot make law by way of an executive order. So executive legislation is an aberration in the constitutional democracy. When you have a constitution in a democracy, you can't use executive arm of government cannot make laws. It's not within their constitutional domain. It's Section 4 says the legislature, constitutes National Assembly, and state houses of assembly can make laws. Section 5, executive arm of government to execute and implement the laws and maintain the laws. So it is not their duty to make laws. So executive order is not bad. It's a directive. It's a directive. I agree with Dr. Buddha. It's novel. It's an importation. It has not been there over time. Historically, it's not been part of our system. But it's an administrative procedure that you use to issue directives to officials within the executive arm of government to carry out a directive based on an existing law, under the Constitution or a statute made by the National Assembly. So you cannot go outside the Constitution or a statute passed by the National Assembly to make an executive order. All you are doing by executive order is to direct your officials within the executive arm of government under Section 5 to carry out what the law says should be done, to give effect to this law or the Constitution. But what we've seen happened in the case of orders, executive orders number 6 and 10 is that the federal government seem to be interfering with the constitutional responsibility of the National Assembly and the State House of Assembly in making laws. Order 6 is about the seizure of suspicious properties acquired by those who have been investigated for corruption. It was signed by the President on the 15th of May, 2018. It was signed as part of an order to pursue the fight against corruption. But the question that comes is this. Under the Constitution, Section 36, subsection 5 says, any person who is facing a criminal trial shall be deemed to be innocent until proven guilty. So the Constitution has recognized the right of every citizen, no matter how heinous the crime is, as he is being tried, he is considered innocent until you prove that he is guilty. Now, how then do you go ahead to seize a person's property when he has not been found guilty of an offense of corruption? Section 41 of the Constitution, I think, says every citizen has a right to own property. Until that right is lifted from him by an order of court, a valid order of court, you cannot deny him access to his property. Now, under the EFCC Act and the ICPC Act, there are verbose provisions on interim forfeiture of assets suspected to have been obtained by fraud and perpetual or permanent forfeiture of assets. So there is an existing provision in the laws on how to forfeit assets suspected to have been obtained fraudulently. So you don't need an executive order. All you need to do is to improve on the efficiency, fast track the judicial system and those prosecuting those crimes so they can get that order from court. The essence of going to court is this. So you could hear from the other party. That's the benchmark in a democracy. Fair hearing. Before you seize an asset, before you impound an asset, you hear the other person. Order 10. Order 10, as good as it may seem, that any money accruing to the state governments that has failed to deploy money made for the state judiciary or legislature should be seized at the point of allocation of revenue to the states that they do monthly. In other words, the Cathedral Federation is empowered to seize assets of states, money from states who have failed, who in their own arbitrary, personal decision have not done what they should do. Section 5.1, rightly speaking, empowers the president to make executive order within the ambit of the law, not to make new law. to maintain and execute the constitution or laws made by National Assembly. Section 5.2 empowers the state houses of assembly, the governor to make executive order for the execution and maintenance of the laws made by the state houses of assembly. In other words, the state governors also have power to make executive orders. In executive order number 10, what the president has done is that he has gone ahead to usurp the powers of the governor to make executive order. Because as it affects section 1213 on money accruing to state judiciary, is the governor that can validly make an executive order. Section 81.3 is where and 162 subsection 9. That's where the president can make executive order as it affects judiciary. So he overstepped his bounds. And that was why the governors forum challenged what he did. And they threatened to go to court. I don't know whether they filed the case in court because the president had no power to make that executive order number 10. So the issue is this: whereas you have the power to make executive order, you must do so within the ambits of the constitution, within the four walls of the law, as empowering you to do so. And in doing so, you don't overstep your bound to begin to make new laws.
All right.
Thank you.
All right. Dr. Chijioke, I will read a part of what Senator Ekweremadu said during his presentation at that law conference, Nigeria Bar Association conference. He said a proper understanding of the context of Section 315 and the reason why it was inserted in the first place will reveal that the provision has duly outlived its usefulness and ought not remain a part of our body of laws. He regretted that the Constitution Amendment Bill to delete the provision from the Constitution in the 8th National Assembly was not signed by the President. So does this worry you, and do you agree with Senator Ekweremadu that the era of executive orders is long gone?
Well, I think his concern about Section 315 of the Constitution is well noted, because that section talks about preservation of pre-existing law. And to my mind, even our customary laws are pre-existing. It does not necessarily mean that the president can, on the basis of subsection 2 of that law, now begin to make new laws, as Barrister Kolo rightly pointed out. You see, he has to be within the confines. The beauty of constitutional democracy is that powers are defined. You don't go outside the limits of your powers to exercise executive authority, which, of course, he does not have. That would be a naked usurpation of legislative powers. So, to answer your question directly, I think that there could be an amendment to that section, particularly subsections 2 and 4, because it is subsection 4 that defines who the appropriate authority is. Subsection 2 talks about the power of the appropriate authority to bring that law in conformity with an existing law of the National Assembly or the Constitution itself. Take, for instance, Section 7.1 of the Local Government Law, which provides that it is the state and the state houses of assembly that shall issue to the establishment, structure, composition, finance and functions of local governments. Does it now create a direct relationship between local governments, which are in the subsidiary level, with the federal government, which is a federal authority? And despite what the courts have said over and over, like in the Attorney General of Lagos State against Attorney General of the Federation, when the strong and the militarized Obasanjo presidency seized the money due to the local governments in Lagos State, that one came up. And why are we talking about it now? Even if it doesn't come as an executive order. But are we saying, have we visited our communities? And since we fund the local government directly, have we noticed a commensurate improvement in our roads and social infrastructure at rural areas? I visited my own community lately. I did not see any signs of that direct funding, manifesting. But beyond that, you see, I think that section really ought to be amended, and the acts put in the Constitution, like the NYSC Act and so on, makes it difficult to amend those acts to bring them in conformity with present day realities. I think it is time to amend them to remove those acts so that they stand on their own as acts of the National Assembly and not part of the Constitution. So to that extent, I agree with Senator Ike Ekweremadu, former DSP.
That's another thing here. I'll just take another excerpt from his submission. Now I'm coming to you, Barrister Cosmos Okolo. Senator Ekweremadu reminded that much as the president had good intentions to get the governors to implement the Constitution amendment granting financial autonomy to states, House of Assembly, and state judiciary. Harvard professors Stephen Levitsky and Daniel Ziblatt warned in their book, How Democracies Die, the road to dictatorship is always paved with good intentions. Now, it's about good intentions versus the rule of law and constitutional provisions. Talk to us about how we can have a middle ground and make sure that the president does not continue to act just solely on good intentions instead of following the Constitution and constitutional provisions.
Yeah, thank you very much. The road to
the road to dictatorship is always paved with good intentions.
That's a good point. And it's appropriate in the circumstance because if you look at the contents of the executive order, ordinarily, they are plausible, they are good. It's like good intentions. But the vehicle through which the president has conveyed that good intention to the Nigerian people is tainted with error, constitutional error, procedural error. Most times I don't fault the president in this regard. I fault his team of legal advisors. Beginning with the Honorable Attorney General and Minister for Justice, who is the Senior Advocate of Nigeria, who should know better. Because why such people are given appointments is to guide the president, who may not be a lawyer, on how to go around the law. But it appears that some people have refused to advise him properly on how to go about some of these things. And so, some people who do not understand the implication of obviating the rule of law, like you rightly pointed out, do not know that if you set aside the rule of law, everyone is at risk. It becomes the rule of force. It becomes the rule of discretion with anybody. It becomes the rule of subjectivity. Anybody can do whatever he or she likes. And it's a huge threat, not just to our democracy, but to our liberty as human beings. That's why there is this insistence that everything must be done within the ambits of the law, the rule of law. Otherwise, anarchy will reign. Survival of the fittest. People will do things the way they like. And so, while we applaud some of the contents of this executive order, is good intention. But all we are saying is that it must be done within the limits of the law, so that we don't set aside the rule of law, which should be the core of every democracy, which is the beauty of democracy. The real dividend of democracy is not tarring roads, or bringing pipe-borne water, or good hospitals, good qualitative education. That's not the real dividend of democracy. These are the rights, the basic rights of citizens. If you are a government, responsible government, you should know that these citizens, because they pay their tax, ought to have these things. The real dividend of democracy is that the fundamental rights of the citizens are respected, that the rule of law is upheld, that you are sure that the provisions of the law are predictable, that when one flouts the law, no matter how high or how low the person may be, the law will take its course. So, good intention, but then wrong procedure. Thank you.
I just looked at our Facebook posts now. Someone on Facebook on our live stream just took a line from one of our promos here. Said a community without a common ground will eventually become a battleground.
Oh yes, apologies to Barrister Sisi Okolo here.
I actually don't know why I'm saying it, but it just kept reverberating in my head. This is Political Voices on 92.5 Enugu's Dream FM. This morning, our focus is on executive orders and democratic governance in Nigeria. This morning, I'm joined by two eminent lawyers, Barrister Cosmos Okolo, Enugu-based lawyer, public policy analyst and executive director, Amrit Leadership Center, and Dr. Chijo Kabo, Enugu-based lawyer. He's also a law lecturer.
Correct.
And a very top-notch one, and political analyst here in the studio. And it's time for us to take the responses from those listening and those watching us on our different platforms, on YouTube, at Dream TV Enugu, on Facebook, 925 Dream FM, and on Twitter at Dream925FM. And you can call the phone lines 0902 0020 925 or 0809 8888 925, or you can call 0811 292 5925. Those are the numbers you can call. 0902 002 0925, 0809 8888 925, 0811 292 5925. Those are the numbers you can call us on. Let's know who's on the line. Hello. Good morning.
Hello, good morning.
What's the name and location?
This is Reverend Henry Bond. I'm calling from Oregon.
You're welcome.
The executive order, president, and the other governors in general, we cannot just narrow it to president alone. It's generally every state. It happens every state. You see what happened in Cross River State, where the lawyer was dealt with. See what happened in the Ebonyi State, where everything is going on. In fact, but basically, we have to also take a picture from the president. Somebody comes to the saddle and say that he is not much interested. That he even accused judiciary that it was the judiciary is the problem. Judiciary are those people who are subordinating his effort to fight corruption, and also the serial litigation that could not allow him to negotiate in terms of issue of corruption. People should not use their own description in winning Nigeria. We have templates. We have to emphasize that we have templates. We have guidelines, things that guide us. And I don't even know why the laws in Nigeria are not even biting. People flag rules and nobody is even holding them culpable. Then they keep on flagging rules.
Thank you.
So there's no way we are just wasting our time here talking about this issue.
Thank you.
People, anybody who gets the use it the way we want.
All right.
I don't know. We should amend our constitution and see this is bad.
Thank you.
And God bless us.
Thank you so much. Thank you. Hello. Good morning. Hello. Good morning to you.
Good morning.
Welcome. Good morning to you.
Hello.
Hello. I can hear you.
Can you hear me?
Yes, I can.
My name is Odaze. I'm reaching you from Ila Delta State. This beautiful morning.
Okay.
Good morning to the gentlemen in the house, the learned gentlemen. I'm enjoying the program.
Good morning,
because
Dr.
I've been so worried about this executive order. The conflict between the legislature and the executive. Gentlemen, thanks for trying to enlighten us some more on this issue. We are learning. Thank you very much.
All right. Okay, then. Thank you so much, Odaze, for your... Let me take a message from Facebook. Aristotle Plato on Facebook, 95 Dream FM says, good morning, Alex. The executive orders and democratic governance in Nigeria are yet to be harmonized for the good of the people of Nigeria, especially since the advent of the current administration. And he said he thinks a lot needs to be done about that. That's how possible... But how possible is it to revisit the Republican Constitution of 1963, because he thinks that the Constitution can help us as a people? Omaga Namani from Amagonza in Enugu State says that he says under a true democratic process, there is a clear separation of powers among the three arms of government for proper checks and balances. In this regard, no arm shall lord it on the other. I must assert unequivocally that the call by Senator Kwaramadu is a wake-up call which should be heeded in order to avert anarchy and authoritarianism. We will take more calls now. Call us on 0800200200925.
Yeah.
Hello. Good morning.
Good morning, Alex.
What's the name and location?
Emmanuel Anutukwe from Nkerefi.
You're welcome.
Yeah, I want to say good morning to the legal luminaries in the studio.
Good morning.
They are doing great. In this discussion this morning, I want to say that we have a lawless president. A president that says that the rule of law is not important, more than national interest.
Hello? Can you hear me?
Yeah?
If you want to make a contribution, you have to keep your language very, very temperate.
Okay, Alex, but let me say, if somebody is not obeying the law, what will he call him?
But you're not. It is not on this radio station. You have to call him that. I'm sorry.
Okay.
Yes, please.
Okay, now, he believes that the nationalist supersedes the rule of law, and that's why he's dishing out executive orders here and there. Anyway, as good as it may look like, his legal advisor should advise him on how to obey the law so that the country will move. Because if he doesn't obey it, then there is no need for the laws. And for locally, in my own local government in Kano East, we are reaping the benefit because our local government chairman is doing better work that has ever local government chairman has done there. Honorable Nwobut.
You are now politicking, right?
No, I'm not.
All right.
I'm telling you the fact.
Thank you.
You look at our bridge.
You have made your point.
And bridge also.
You have made your point. All right then. Let's take a message from Facebook. Comrade Jeremiah Okore says, if Nigerian justice system is what it is meant to be, there won't be any need for executive orders in the first place. And let's take another call. Hello. Good morning. Hello. Good morning. Hello, good morning.
Hello.
What's your name and location? All right, I think we lost that. More messages now from Facebook. Solomon Ebuka AG says, traditional rulers, can they issue executive orders like it happened in my village? Is it an exclusive right of the president? Hello, good morning. Turn down the volume of your radio, please. Hello. All right, then. Let's take another call here. Hello. Hello, good morning.
Hello. Good morning, Alex.
What's your name and location?
Yeah, my name is Roman. I am calling from Nsukka.
You're welcome.
Yeah, you see, as your guest, reading out the constitution, the laws. We have some beautiful laws in our constitution. But the problem is implementing it. The institution that enforcing those laws, they are the ones.
All right, then. We'll go back to the phone lines in a moment. But there are a few, they've made contributions here that suggest that it does appear that people have great expectations, not just of their president, but of the legislature. But there's another concern. Someone is saying that it's not only the president that is issuing executive orders. I want to find out from you, Dr. Chijekabo, do we have that concern that it's becoming a free-for-all? The executive orders, anyone in an executive position makes pronouncements and it takes the force of law. Is this something we should condone in the country?
I think in a constitutional democracy we shouldn't, because just like my co-discussant Barrister Kolo said, the rule of law is always there and there is procedure for it. You see, when, as Ibo was saying, so if from the highest level we see such issue of orders, and even when the courts decide, people hardly, the institutions of government hardly obey. And those people that issue those executive orders will not issue orders to compel them to obey. Is itself disturbing. And so sometimes some people look at the executive orders, yes, well-intentioned though, but the vehicle of conveying it to the people is faulty. And that is flowing down. In the case of the president, he has, in the main, reduced those orders into print, committed them into print. But at the state level, we see governors issue orders, arrest this person, deal with this person, lock up this person. They are verbal orders, but they are emanating from an executive governor. So people take it, they are executive orders. But most times they flout the provisions of the Constitution. What are the expectations of the people? People can rightly expect that the government should attend to them, defend their rights, provide for their welfare and security. That is the fundamental purpose of government. Otherwise, each and every one of us in Nigeria can set up his own government and stay there. But what do we get in a society like that? When the rule of law takes the back seat and the rule of man is promoted, we get back to the era of the sophists, Thrasymachus, where the might is right. So, is that what we want in Nigeria? That is not what should obtain in a democratic setup. And so we must go back to the rule of law. There's no escape route from it. That is the way to go. Now, fundamentally, as Barrister Okolo rightly pointed out, that constitution is not autonomous. It's not the people's constitution. And so the sovereignty does not seem to reside in the people. Because those who are in positions of exploitative advantage, by virtue of that constitution, will continue to subvert it and will continue to prevent the people from enjoying the dividends of democracy. Take the judiciary, for instance. The way in which the former Chief Justice of Nigeria was removed, did it follow procedure? And since that time, the judiciary in Nigeria has never been the same. Since the time Honorable Justice Onayan was removed through an ex parte order, and we are yet to recover from it. Take the recruitment, the appointment of judges. And is the executive not overbearing? And do we not say in common parlance that he who pays the piper dictates the suit? How many can in that circumstance stand up and uphold the rule of law? I am happy though, if I may overshoot, that the president said he expects that criminal matters should take 15 months from the court of first instance to the Supreme Court. I hope he walks that talk. Because is
it the president that will make that happen?
Well, he has to, yes, because there are constraints in the judiciary. Do we have enough judges? We don't. In some other points,
where do the judges come from, really?
The judges come from our society. The judges come from our society, yes. But because of their judicial oath and because of their training, they are supposed to abide by, that oath and the rule of law and uphold justice. But the problem is, if the system that provides for the procedure of appointment is followed, then you will expect that from them. Not when, by executive fiat people are appointed. How can you expect them to go against those that appointed them? It will be difficult.
Okay then. Barrister Cosmos Okolo, Senator Ekweremadu called on the Nigeria Bar Association and other public interest groups to act as gatekeepers by seeking the intervention of the courts at the earliest opportunity against any executive orders, especially when the executive orders are in violation of constitutional provisions for the principles of separation of powers. How can associations like yours, you are members of the Nigeria Bar Association, how have you worked hard in this direction, especially looking at since the inception of this administration? Do you think that the NBA has really walked the talk in this direction?
Well, thank you very much. The responsibility of challenging executive lawlessness applies to every citizen of Nigeria. Let's not just cite it as it applies to lawyers. Every citizen of Nigeria has a right to challenge. You also mentioned public interest groups. I'll come to your point. Individual citizens of Nigeria, public interest groups, civil society organizations, then of course the NBA, the body that comprises legal practitioners in Nigeria, has a responsibility to challenge such things. As it applies to the NBA, we have a challenge. And that challenge is that the organizations seem to have lost, like we had in the days of Basharun, Alawaka Basharun era. Right. Because the people who are emerging in the executive and leadership of the NBA seem not to have understood their place as gatekeepers.
Exactly.
As it affects the Constitution, as it affects the rights of citizens. Maybe through this forum we can make a call on the NBA at different branches at the national level to rise to the occasion and challenge these infractions of the Constitution at any point it occurs. But the most important thing we should do, which Dr. Abu rightly pointed out, is the issue of the perilous state of the judicial arm of government in Nigeria. This same constitution I've referred to earlier has said the governor or the president appoints judges on recommendation of the NJC. But if you ask me my own candid view, they should not have any role in the appointment of judicial officers. it should begin and end with the points of the State Judicial Council or the NJC at the national level, for federal national courts, as the case may be. Because this procedure for appointment is very critical. If you appoint an incompetent person throughout his service year, he will show you incompetence. Most of the confusion we have in our system today, as it affects judiciary, is people who are not qualified to go there in the first place. Granted that there are people there who are doing their work judiciously, meticulously, conscientiously. There are so many of them. But those who have come in without being qualified seem to have given a bad image to the system. But then the system has its own inherent challenges: funding, facilities to work. If you enter some court halls, you wonder, is that where a judge sits for hours in a day writing on longhand without the basic facilities that he needs to work? Their condition of work should be improved upon, so that when you file these cases, sometimes you file a case in a court that has docket cases of about 1,000, and you are asking that an executive order should be decided whether it's valid or not, and your matter is pending for the next 4 years. And the president who made the executive order has left office. You are still asking the court to interpret whether the executive order was right for 4 years. So the system has its challenges, like Dr. Bo said. We need to appoint more competent judicial officers. We need to create more judicial divisions. Then we need to improve the welfare of judicial officers. Their pay, what they need to work, their cars, their accommodation, and everything they need should be provided. And again, I had expected this present government, federal government, to establish specialized courts against corruption. Special courts, just like we have the National Industrial Court, just like we have the other specialized courts that we have. We need a court specialized to deal with issues, because the major challenge we have in Nigeria is corruption. So we need a specialized court that will do it, and the president is in the position to do so. So I expect, before leaving office, to, even if it means to send an executive bill to the National Assembly requesting for the creation of special courts to deal with cases of corruption. Then what he has said about timeline for deciding such cases should be in the procedure, in the rules of court, to guide that court, so that we can deal with judicial cases of corruption more expeditiously. Thank you very much.
All right. As we wind down now, Dr. Chijioke, one of the final submissions of Senator Okpara Madu on this issue is that, in fact, the executive should mind their business as is stated in Section 5 of the 1999 Constitution, and he proposed that the executive should seek a resolution of 2/3 of both houses of the National Assembly if there is a need for an executive order. Do you think this is the way to go?
Well, I agree that the executive should not overreach itself. But as I said, there are some laws, that provide for subsidiary legislation. Must all those subsidiary legislation now go to the National Assembly for 2/3 approval? So I think that will be a very tall order, and it may not make for efficiency in the delivery of goods for a government that is really committed to delivering the goods. But having said that, I agree entirely, that they don't go outside the bounds of using it as an administrative tool.
Correct.
Within the executive branch, to make sure that agencies of government perform. To that extent, yes. But to the extent of transforming it into a kind of legislation that that the presidency or the governor now competes as, a lawmaking authority, as it were, is wrong. But generally, to address the problems fundamentally, is that we need a new constitution. We need to do a thorough review, thorough drafting of a new constitution to move Nigeria forward. Otherwise, we'll continue to make a lot of false steps. Correct. We'll continue to be in motion without movement.
All right. Let's take some more calls. 0809 888925. All right. We'll try to take even some messages on Facebook. You can call us on 0809 888925 or 0902 0020925, or you can call us on 0811 292 5925. Looking at submissions here, we have still have messages on Facebook that we need to attend to here, and this one is from Nats Nwoko. It says, the wave of executive orders shows that we have a legislature that is not functioning. And we also have some messages that we've taken before. And let's take a final phone call before we get to final thoughts. Hello. Good morning.
Hello, good morning.
What's your name and location?
My name is Anya Okiri and I'm calling from Oka.
Yes, you have 30 seconds. Okay.
I see this executive order as something like a fire extinguisher. And you need fire extinguisher only when you want to extinguish fire. So the president should not be using it when it's not necessary. Or does the president want to do the work of the executive and the at the same time, the legislature and executive at the same time? So he should just leave the work of the lawmakers to the lawmakers and do his own work of executing the law. Thank you.
All right, then. Thank you so much. I need to get your final thoughts now. Barrister Cosmos Okolo, to talk to us about what your final thoughts are about the issue of executive orders and the way forward on the matter.
Thank you very much. Executive orders should be used circumspectly, should be used carefully. Like one of the callers asked, that his traditional ruler made an executive order. He has no right to make an executive order.
Or maybe he made a traditional order.
A traditional order, maybe. And then, before a traditional order, it must be on consensus. What are they called? Igwe in council will have to resolve. All the heads, representative of heads of different families will have to resolve. That's how issues are taken in our... So but it goes to point out the fact that most things in Nigeria are liable to abuse, and it's because of our over-militarized system. We're still living with the vestiges of military rule. So people would give order and all that. You see this trend we are seeing now in Nigeria. When you see a house you feel is not in order, you go and pull it down without even approaching the court to hear from the other side. Did you get approval? When did you do this? So these are things. Rule of law says allow the other side to be heard before you take action, executive action. So this order. We should be careful so that it will not destroy the system. Thank you very much.
All right, Dr. Chijukabo, your final thoughts.
Well, I agree with. I align myself completely with what Barrister Okolo said. We should be circumspect about these executive orders, and again, we must adhere to the rule of law. Let's avoid the rule of man. And again, if you have a strong president like this, it is also possible that you may give advice, and the advice by its nature may be subject to acceptance or rejection, and you may ignore the advice. So I believe that the presidency, those in positions of responsibility, the governors, the local government chairmen, and so on, must work in the interest of the people to deliver welfare and security to the people.
All right, then. Thank you so much, gentlemen. Barrister Cosmos Okolo, Enugu-based lawyer, public policy analyst, and executive director, Amrich Leadership Center. Thank you.
My pleasure. Thank you, Alex.
Program. And Dr. Chijukabo, Enugu-based lawyer, political analyst, and a renowned law teacher. Thank you for your insight on the program.
Thank you very much.
Morning. And special thanks to my production assistant, Lutana Okereke, and my producer, Okeodogu. Political Voices that journs till Monday. My name is Alex Obodo. Good morning.
Hello, Nigerians. A new British school is opening in Nsukka, Enugu State.